Hello students, I'm Dr. Akanksha Srivastav and I'm Associate Professor in Department of Business Administration at Lal Bahadur Shastri Group of Institutions, Lucknow. In today's class, I will discuss the Payment of Gratuity Act 1972, and it is a part of Unit 5 of the paper Employee Relations and Labor Law, and this paper is there in MBA third semester and it is an HR specialization. Okay. So, start with the Payment of Gratuity Act 1972. In today's class, I will discuss introduction. What is the meaning of gratuity, right? What is the term gratuity is exactly, that I will discuss. Then what is the definition of employee entitled, right? Under this act, the Payment of Gratuity Act, there are certain definitions. So, according to this act, who are the employees who are entitled for gratuity, that I will discuss. Then, to whom gratuity is payable in case of death. The employee who is entitled for gratuity, if he dies, in that case who will receive that gratuity amount, that I will discuss. Then continuous service. What is continuous service according to this act, the Payment of Gratuity Act 1972, that I will discuss. Then how we will calculate gratuity, right? How the gratuity for an employee will be calculated according to in which type of job he is engaged, like he is working in a seasonal establishment, or he is working in a non-seasonal establishment, or he is a piece rate worker. So, according to that, how we will calculate the gratuity, that I will discuss. Then there is a ceiling of the amount of gratuity. So, what is this ceiling, that we will see today. And there again there are certain deductions which are permissible by the law, which an employer can deduct from the amount of gratuity, that we will see. And we will discuss about the compulsory insurance. Okay. There is a compulsory insurance for the payment of gratuity, and why it is compulsory, that we will discuss, right? And 4 feature of gratuity. What are the conditions in which employer is liable to forfeit the employee's gratuity? What are these situations, that we will discuss. These are the main provisions of the Payment of Gratuity Act 1972. Okay. So, introduction. First of all, it is one of the retirement benefit. Retirement benefit. Gratuity is a retirement benefit. That means what? When an employee separates from his employment, at that time he will receive the amount of gratuity. Okay. It is a retirement benefit. An employer provides gratuity to his or her employee for rendering long and commendable service. Long and commendable service. It is not like any employee has joined the organization just for a year or 2 year or 3 year, or he will be entitled for the gratuity. No, it should be long and commendable service, right? And how long, that we will discuss. Gratuity is non-contributory. Non-contributory means employee need not to contribute anything for gratuity. Only employer will contribute for the gratuity amount. So, for employee it is a non-contributory. Then it is an expression of gratitude. It is an expression of gratitude of employer towards his or her employee. But after the enforcement of this act, it has become a statutory right, Before this act was came into force, it was simply a gesture of gratitude, or it was simply an expression of gratitude. If employer feels towards any employee that he has given his whole life to the establishment, he is very loyal employee, he is very punctual, he is very hardworking, and I am very happy with this employee. So at the time when his services is about to terminate, I should give some gift to him. So this is simply a gesture of gratitude, or it is simply an expression of gratitude before the enforcement of this act, right? But after the enforcement of this act, it has become the statutory right. A statutory right means what? Employee can claim for the gratuity from his employer. It has become statutory. An employer has to pay the gratuity amount to his employees if he is entitled for gratuity. It has become statutory after the amendment of this act. The act is extended to the whole of India. It is applicable everywhere in India. Okay. Now, employee entitled. What are the conditions and what are the situations which makes an employee entitled for gratuity? Number one, every employee other than apprentice. Apprentice are not entitled for gratuity. Other than apprentice, every employee is entitled for gratuity, right? Irrespective of his wages. This is the second condition. If you remember, I have told you in the previous act, that was the Payment of Bonus Act, there was a condition: every employees whose salaries up to rupees 21,000, only those employees are eligible for bonus. But here in Gratuity Act, it is irrespective of his wages. Whatever salary or whatever wages an employee has drawn from his employment, it does not matter, he is entitled for gratuity, right? Rendered continuous service of 5 years or more. At least an employee has to work for 5 years in an establishment, at least 5 years. If he has worked for 5 years, then and only then he will be entitled for the amount of gratuity. Gratuity is payable at the time of termination of services, right? That I have already told you, it is a retirement benefit. So, it will be paid at the time of termination of services. And termination of services can happen. The first condition is superannuation. When an employee reaches at the age of 58, that is called superannuation or superannuated. So, when an employee reaches at the age of 58 and due to that there is a termination of services, at that time the gratuity will be paid. At the time of retirement or resignation, right, if any employee takes voluntary retirement or voluntary resignation after serving 5 years, right, after serving 5 years, then he is entitled for gratuity. Or there is a termination of services because of death or disablement of the employee. If the entitled employee dies, or if he becomes disabled due to any accident or due to anything, in that case also he is entitled for the gratuity amount. There is one more clause according to section 4. The clause of continuous 5 years of service is not obligatory if services are ended due to death or disablement, right. Here there is a condition, employee has to work at least for 5 years, right. This will be obligatory or this will be compulsory In case of superannuation, it is obligatory. In case of retirement or resignation, but it is not obligatory in case of death or disablement. If an entitled employee dies within 2 years after he has joined the establishment, or 3 years, or he has become disabled before 5 years, then he will remain entitled for the gratuity. The clause of 5 year is not obligatory in this situation, right? So, what are the conditions which make an employee entitled for gratuity? This is clear, I believe. Now, to whom gratuity is payable in case of death? If the entitled employee dies, in that case, who will receive the amount of gratuity, that I am going to discuss. So, in case of death of employee, gratuity is payable. There are two conditions. If the employee has nominated someone, right, and if the employee has not nominated someone, there could be two conditions. The employee who was entitled for gratuity, he can nominate someone. In case if something mishappened to me, then this is the person who will receive my gratuity amount. Or other case will be, he may not nominate anyone. So, in case of nomination, the nominee will receive the amount of gratuity. Okay. In case of no nomination, any legal heir, whosoever will be the legal heir for that employee, that person will receive the amount of gratuity. Again, there is one more condition. The nominee or the legal heir, that person is minor or major. That means that is above 18 or below 18. If the person is major, either nominee or the legal heir, right? If the person is major, then he will receive the gratuity amount. The gratuity will be paid to that person who is major. In case if the person is minor, that means he is below 18 years, then what will happen? Gratuity will be transferred in a term deposit. Term deposit, that is basically FD, right, fixed deposits, by the controlling authority for the benefit of minor, right. In that case, if the person is minor, he will not receive the gratuity amount until he will reach the age of 18, and that gratuity amount will be transferred in a term deposit by the controlling authority for the benefit of the minor. It is deposited somewhere in government banks. Okay. So, in case of death, who will receive the gratuity? This I have shown with this diagram. Okay. Now, what is continuous service according to this act? Continuous service is defined as uninterrupted service. Uninterrupted service. But there are certain interruptions which are included in this uninterrupted service. And what are these interruptions? If there is a interruption due to sickness, so that interruption is considered in continuous service. If there is any interruption due to accident, if an employee has met any accident and due to that there is a interruption in the service, then that interruption also considered as a continuous service. If any employee is lay off, that situation is again considered as a continuous service. A strike and lockout. A strike is because of employee, right, and lockout is because of employer. I am not going to get into the detail what is a strike and what is lockout, but because of these two terms, if there is a strike in the organization, of course legal strikes, and if there is a lockout in the organization establishment, if there is a interruption in services because of these two, then again it will be considered as a continuous service. The next condition is cessation of work. Cessation of work means stoppage of work not due to the employee's fault. If in the establishment there is a stoppage of work where employee has no fault in that, due to that there is an interruption in the service, again that will be considered as a continuous service. Then next condition is employee having been superannuated, re-employed by the employer without any break in service. What does this mean? In certain organizations, after retirement or after at the age of superannuation, the employee joins back if he feels fit and with some mutual consent between the employer and employee. If employee joins back without any break in service, then that condition also will be considered under continuous service. There are few more conditions for continuous service. Let's see. In case of mines, right? In case of mines, and if an employee has worked at least 190 days in 12 months or 95 days in a 6-month period, right? This is the condition for mines. In the case of mines, if an employee has worked for 190 days in 12 months and 95 days in 6 months, so that will be considered as continuous service. In case of non-seasonal establishment, non-seasonal establishment means what? Those establishment who remains in operation throughout the year, those are non-seasonal establishment. So in non-seasonal establishment, 240 days in 12 months and 120 days in 6 months period, that will be considered as continuous service. Okay. In case of seasonal establishments are those establishments who cannot remain in operation throughout the year. For example, sugar mills. Okay. So in seasonal establishment, according to section 2 subsection A, any employee has worked at least 75% of the days on which the establishment was in operation. For example, in any year or in any season, if the establishment was in operation for 100 days, right? So any employee who has worked for 75 days, it will be considered as continuous service. Strike through illegal. Yes. Lastly, I have talked in previous slide, I have talked about the legal strike. If there is any illegal strike, but without any fault of the employee, yes, the strike is illegal, but there is no fault from the employee side, then that again consider that the situation again considered into a continuous service. Then public holidays including Sundays. All the public holidays including Sundays, this is again considered under the continuous service. So these are certain definitions which defines what is continuous service under the Payment of Gratuity Act. Okay. Now how we will calculate the gratuity. There are certain conditions. The first one is for the employees in non-seasonal establishment. Non-seasonal establishment, I have already explained it to you what are non-seasonal establishment. So how we will calculate the gratuity for the employees who are working in non-seasonal establishment. The formula is 15 days wages and we need to multiply it with number of completed years of services, right? Number of completed years of services. This is the formula. How we will calculate the gratuity for non-seasonal establishment? we have to calculate first 15 days wages and we need to multiply that with number of completed year of services, right. How we will calculate 15 days of wages? First we need to calculate the wage of 1 day and then we have to multiply it with 15. So, we can find out the 15 days wages. So, how we will calculate the 1 day wage? Monthly wages last drawn divided by 26. We assume a month of where the days are 26, not 30 or 31. We assume it ki in a month there are 26 days, right. So, for example, for any employee monthly wages that is last drawn, it is 2600, right, it is the monthly wages. So, we have to divide it by 26 because there are 26 days in a month. So, what will be the 1 day wage? It is rupees 100, right. This 100 rupee is a 1 day wage, that we have to multiply it by 15, that is rupees 1500, okay. It is the 15 days wage, and this 15 days wage, suppose he has worked for 10 years in that establishment. So, 15 days wage is 1500 multiplied by the number of completed year of service, that is 10. So, that is 15,000. This will be the gratuity amount which an employer will pay to the employee, right. The second condition, for piece rated employee, the employees whose wages are based on the per unit production, in that case how we will calculate the amount of gratuity. The basic formula remains same here. You can see 15 days wages multiplied by number of completed years of services, right. But how we will calculate this 15 days wages, it is different. What we need to do? Wages excluding overtime wages for the period of 3 months immediately preceding the termination of his employment. This we need to calculate, and we need to divide this number of working days in such period of 3 months. So, with this we will be able to calculate the wages of 1 day, right. What we need to do? We need to calculate the wages. We cannot include overtime wage in that. Other than overtime wages, we have to calculate the wages for the period of 3 months immediately preceding the termination of his employment, and we need to divide this with the number of working days in such period of 3 months. So, by this we will get 1 day wage, right. And in this 1 day wage we need to multiply it by 15, okay, and we will find out the 15 days wage with this formula. We will put this 15 days wage here and multiply it by number of completed years of services, and we will calculate the gratuity payable for piece rated employees, okay. Now, how we will calculate the gratuity for employees employed in a seasonal establishment, okay. Here the entire formula is different, not exactly entire formula is different, but yes, some part of formula is different. How we will calculate the gratuity in seasonal establishment? We have to calculate the 7-day wages for each season. In one season, what is the wage of 7 days for an employee, that we need to calculate, and then we need to multiply it by the number of seasons for which employee was employed. With the help of this formula, we can find out the gratuity payable to those employees who are employed in a seasonal establishment, right. So, these are certain formulas through which we can calculate how much gratuity should be payable to the employees in different variety of jobs. Okay. Now, the next thing is the ceiling of the amount of gratuity. With effect from 29th March 2018, it is a recent amendment. With effect from 29th March 2018, the maximum limit of gratuity payable is from 10 lakh to 20 lakhs. It is a recent amendment. Okay. Now, there are certain deductions permissible from the gratuity. What are these deductions? Any damage or loss or destruction of employee's property due to negligence or willful omission. If employee has damaged any employer's property deliberately or due to negligence, it does not matter. The amount which he has caused damage, it can be deducted from the gratuity. Any subsistence allowance, any payment of loan and professional taxes which he has maybe taken from the employer, then employer may deduct that amount from the gratuity. So, these are certain deductions which are permissible from gratuity. Now, what is compulsory insurance? According to section 4A, employer obtain an insurance for his liability of payment of gratuity under this act from the LIC of India or any other prescribed insurer. It is not the medical insurance, it is not the life insurance, it is the insurance for the payment of gratuity. We have talked about if there is something mishappening to the employee, but here what we are discussing, if there is any mishappening with the employer, then who will pay this amount of gratuity? That is why this compulsory insurance is mandatory under this act. An employer has to obtain this insurance for his liability for the payment of gratuity. This is compulsory insurance. And what are the cases where the gratuity can be forfeited? The first one, there are two conditions. The first condition is if employee has caused any damage. So, employer can forfeited the employee's gratuity completely or to the extent of the damage or the loss so caused. That is number one. Or number two, if employee is engaged in some riotous behavior or disorderly conduct, in that case also employer can forfeit the employee's gratuity. If employee is engaged in any act of violence, then again employer can forfeit the employee's gratuity. Employer is liable. If employee is engaged in any kind of violence activity, then employer is liable to forfeit his gratuity. If employee is engaged in any kind of moral turpitude means any kind of emotional attack. In any establishment or in any organization, there are certain acceptable standard of behavior, and if an employee is not showing or is not meeting those standards which are acceptable in the establishment or in the organization, in that case also employer is liable or employer has the permission to forfeit the employee's gratuity. So, these are the main and important provisions of the Payment of Gratuity Act, and with this act is over. So, thank you.